What are some other considerations for the committee when reviewing an arbitration request? Let's take a look. First, just as with ethics complaints, the committee must make sure that the request is in proper form. Is the arbitration request form fully completed and signed? Does it cite a specific dollar amount being sought by the requestor? This amount cannot be greater than the amount in dispute. For example, it can't include things like interest, or attorney's fees, or miscellaneous damages. Does it name the appropriate parties as respondents? Is it based on a transaction that has closed? Is the appropriate filing fee or deposit included? Unlike ethics complaints, where no filing fee can be charged, local boards can require filing fees of up to $500 from both the complainant and respondent in arbitrations. Is there a written statement attached to the form that details the basis for the request in sufficient detail for the committee to make a determination? And has the request been filed within 180 days after the transfer of title, or within 180 days after the facts constituting the matter could have been known in the exercise of reasonable diligence? Let's assume that the Grievance Committee has reviewed an ethics complaint and has instructed the board's Professional Standards Administrator to arrange for a hearing. Now what? If they haven't already, the first thing the administrator will do is to notify the respondent that a complaint has been filed against them, provide them with a copy of the complaint, advise them of the Grievance Committee's action, and provide the respondent with an opportunity to file a written response to the complaint. In order to provide due process, the respondent must be provided a complete copy of the complaint in order to know what the charges and allegations are, as well as an opportunity to file a written response prior to the hearing. The next step of the process involves another standing committee of the board, called the Professional Standards Committee. The members of this committee provide the pool of panelists used for both ethics hearings and arbitration hearings. They should be well versed in the Code of Ethics, as well as the arbitration guidelines promulgated by the National Association. We mentioned that one of the most important aspects of due process is the right to an impartial hearing panel or tribunal. To accomplish this, the administrator must afford the parties to a hearing with the opportunity to challenge the prospective panelists for cause. Note that on the form, the party objecting to the prospective panelist must state a reason, and the form further stipulates that unsubstantiated challenges will be disregarded. The next step is for the administrator to notify the parties concerning the hearing date and time, and the names of the panel members. This notification is accomplished by issuing the official notice of hearing to all parties, via certified or registered mail, at least 21 days in advance of the hearing date. Why a minimum of 21 days? Think back to those due process issues. One of them was the right to have adequate notice in order to prepare for the hearing, hence a minimum of 21 days. Let's now jump to the actual hearing itself. The panel members are focused on determining whether any violations of the Code of Ethics occurred on the part of the named respondent. In making this determination, the standard of proof that the panel will utilize is clear, strong, and convincing. What does this mean? It means that the testimony and evidence presented must rise to the level clear, strong, and convincing that the respondent realtor violated the code. Not maybe, possibly, good bet, 50-50, but clear, strong, and convincing. And it must also be made clear that the parties to the hearing, the complainant and the respondent, are responsible to make or break their cases. That's not the responsibility of the hearing panel. The panel is present to hear the relevant arguments, testimony, and evidence as provided by the parties to the hearing, as well as from any witnesses who are present to provide testimony. The panel members can also ask questions at any time during the proceedings, in an impartial manner as they deem relevant. We can't emphasize the word impartial too much. If any of the panel members have a personal agenda, a bias against one of the parties or against a particular business practice, then due process is not being provided to the parties. The script of the hearing is very straightforward. To begin the hearing, the chair will read an opening statement indicating how the hearing will be conducted and will swear in the parties to the hearing. The complainant presents their case first, providing their opening statement as well as their evidence and witnesses. The respondent obviously has the right to cross-examine the complainant as well as any witnesses. The respondent then presents their case, providing relevant statements, evidence, and witnesses, with the complainant exercising their right to cross-examine. Then both parties present a closing statement, beginning with the complainant and ending with the respondent. At that juncture, the parties are excused, and the panel goes into executive session. Let's take a brief look at a hearing in progress. I think you may recognize some of the participants.